You've handled, I don't even know how many cases you've probably handled in your career up to this point. If you had to guess, what is that ballpark number? Amount of cases that you've handled?
In my career, that feels weird. By many
Why
standards,
is that weird?
well, because I think a lot of people would still consider me early in my career.
Sure.
An eighth-year lawyer. I haven't been doing it like some of these guys, 20 to 30 years.
Sure.
But I've handled probably around a couple thousand of these by now.
Okay.
Of these first-party property cases. I've done life
Sure.
insurance, some car cases too.
Okay. So out of thousands of cases, this is probably a hard question, but is there one that sticks out to
Well,
you?
yeah, there's a bunch that stick out, right?
What's
that I love still thinking about. You have a couple where you're like, I wish I'd said that. You
Right.
still got a result for the client, but you're thinking, I do that differently. You learn all the time. But yeah, they're like if I have to talk about one,
Sure.
Is that what you mean?
Yeah.
The ones that tend to stick out the most are these cosmetic exclusion cases.
Okay.
I love these.
Good old cosmetic damages.
Yeah,
Yep.
this is where you can really dig in, get academic about these things.
Okay.
Contract interpretation, burden shifting.
Yep.
All this stuff that can make the practice of law fun. And I have a few of those that really stick out. One of them, though, it was an Allstate case. And it didn't even start out as my case. We had another lawyer here, David, who had been working on the case. And then the case was going to trial. And he approached me with this set of facts that I just was blown away. Like, what is Allstate thinking?
Yeah.
You often learn Allstate's not thinking.
Okay.
Right?
What was that?
No
what
offense,
was,
Allstate.
What was that elevator pitch?
Yes,
The quick
offense,
facts.
Allstate.
Yeah, real offense, Allstate. What was the elevator pitch of the facts for that? What was a little rundown of?
So, a standing seam metal roof in San Antonio after
Okay.
the April 2016 hailstorm, which was the costliest and biggest hailstorm in Texas state history.
Okay,
Right.
I didn't know that. Wow.
Yeah, as a storm, I think in terms of the amount of damage it caused, it's only exceeded by a couple of hurricanes like Harvey. And
Okay.
yeah, I mean, that's how...
Big storm we're talking.
Yeah. It was a perfect storm. Massive hailstones, softball size, 3.5, 4 inch, that hit a heavily populated urban area and car dealerships and all kinds of stuff. And so we had this kind of salt of the earth husband, wife, lived in San Antonio, worked their whole life. They were very proud of their home. They had a standing seam metal roof in a neighborhood where the HOA required everybody to have a standing seam metal roof. And Allstate comes out and looks at the roof and says, sorry, it's cosmetic damage. And throughout the whole dispute, they had these experts that they brought in.
Okay.
Engineers.
Experts, right? Sure.
I don't know how these guys sleep at night. I mean, they had this pseudoscience nonsense that the hail didn't exceed 1 inch, and so it couldn't have damaged this whatever gauge standing seam metal roof. The problem is, in the middle of the storm, when it's the storm of the century, a lot of people don't just stand there and watch, right? In the age of cell phones, they're taking pictures. Of the
Video,
hail.
yeah, of course.
Right.
They're all over.
And
Sure.
And Mr. Insured reaches out the door and just grabs one of the hailstones, and it's literally the size of a softball. I mean, I know because I measured it. I measured a softball in front of the jury, and then we compared it to the photograph that we had. Mr. and Mrs. Insured were smart enough to know that, hey, we can't prove how big this hailstone is unless we put it next to a ruler.
Right.
So they had a quilter's ruler in the photograph, and it measured 3.5 inches in diameter. And despite that, in a 9-day trial, Allstate argued the whole time, that the hailstones did not exceed an inch in diameter.
How can you seriously make that argument with pictures, with video? Didn't y'all check the hail trace report? Didn't you do any due diligence? Mm-hmm. It's a ridiculous argument.
Their experts were even saying that we look at NOAA. Well, what about this, sir? Have you looked at this? Because NOAA was saying, Next Generation Radar was saying right there in the neighborhood, up to 4-inch hail, 100% probability, severe hail too. The local storm spotters, their reports lit up like a Christmas tree on
Right.
NOAA. And they weren't reporting 1-inch hail. I mean, they were reporting catastrophic hail. And then the other thing you have, and I love these situations because a hailstorm of that size, when you're selecting a jury, right? It's easier to ask who doesn't remember the storm and get one or two hands rather than ask how many of you remember the storm. I mean, they all remembered it, and they all remembered how bad it was. And so Allstate had the nerve or the gall to walk in there and try to pull the wool over people's eyes with their moral-less engineer who was trying to say 1 inch.
But absolutely ridiculous.
It was silly, to the point where you're thinking the whole time, like, what am I missing here? But from a lawyer's perspective, where this case got really interesting was it had to do with contract interpretation. And I know in talking to a lot of contractors and public adjusters out there, we talk about these cosmetic exclusions all the time.
Right.
It's really important to look at the exact wording of the cosmetic exclusion because it varies from policy to policy, right? Some of them will say it's cosmetic if it doesn't affect the water shedding ability of the roof. Some of them will say it's cosmetic if it does not inhibit the roof's ability to perform as a barrier to the entrance of the elements to the extent it did before. And this one was unique. Allstate has its own. They have a few versions out there, but this one, if I remember, it said it's cosmetic damage if it's dents, dings, bruising of the roof. That only, and this was key, that only affects the appearance of the roof, right? So dents, dings, scrapes that only affect the appearance of the roof.
They backed themselves into a corner with that, right?
Well, I think they did because and this is very important. A lot of defense lawyers get this wrong. I know for a fact some plaintiffs' lawyers get this wrong too. Not at our firm. They don't understand that this is the
nod to the camera.
Nod to the camera. This is it's the insurance company's burden to prove that it's cosmetic damage. It's not my client's burden. It's not my burden as a plaintiff's lawyer to prove that it's cosmetic damage. That's their burden, and Texas law is really clear about that. The Texas Insurance Code says that an exclusion is what is known as an affirmative defense. An affirmative defense is a defense, like, well, you're a lawyer. Yeah. It's a defense where the defendant or the party asserting that affirmative defense has the burden to prove it. Right, so I got to prove my case, right?
Right.
I have to prove that a sudden and accidental loss happened, and then the burden shifts to them if they raise an affirmative defense, and they bear the burden on that.
Right.
Well, yeah, they back themselves into a corner with that language because, guys, you have to somehow prove to a jury that this 3.5-inch softball-sized hail only affected the appearance of the roof, and so Allstate and Allstate's lawyers, they knew they had a problem. So what they did was they tried to argue that it wasn't about proving a mere effect to the appearance of the roof. What they said that we had to prove, not them, but that we had to prove, was that there was a hole through the roof on day one. So the moment of impact, softball-sized hail comes down, and we have to prove that
there was a hole in it.
Yeah, there was a hole in it.
Just completely false. That's not what your burden would have been.
Yeah, right.
By any means.
Right. And I even said to the jury in closing argument, like, what do they buy with this policy? If that's true, maybe they'll get lucky and a meteor will come through the roof or something.
Right.
But that's not in the language. And so our cross-examinations of the adjuster, their experts, the agent, their corporate representative from Allstate, it was really uncomfortable for them because we kept pressing them. Where does it say that? It doesn't say that. It doesn't say that. It doesn't say that. So despite the jury had made up their mind, I could tell during closing argument, and they were upset because they knew they were being lied to. So
right. That's a good feeling from your perspective, I'm sure.
It is. Well, it's still nerve-wracking. I don't care how you feel about a jury. You don't know what they're thinking until it comes out, and you're on pins and needles while they deliberate. But they came back. It was a great verdict for our clients. But these cases are not always over, right, at that point. Because Allstate, they still didn't get the message, right? So they decided to appeal it. And if you ever need vindication or something, a court of appeals is a great way to say, I told you so.
Right.
And the Court of Appeals, after all these years, recently came down with an opinion and said, your policy doesn't say that, right? Your policy does not say that there has to be a hole through the roof at the moment of impact. Which I want to put this in perspective from the legal world because that's embarrassing, right?
Yeah, for Allstate.
Right. The whole right, very much. Yeah, not for me. Right. But that's really embarrassing because the homeowner, the insurer, the contractor, the public adjuster, the plaintiff's attorneys were not writing these policies. There's one entity that's writing them. It's Allstate, and you would think they would know what they're writing, right? I have no excuse if I write something down and it's plain and unambiguous and you know what it means. I have no excuse for pretending I didn't know what it meant.
Right.
And for them to go in front of the Court of Appeals and then be told that, guys, you wrote this, your policy doesn't even come close to saying what you say.
Right.
It's pretty embarrassing. And so that's a long-winded way of telling you why that case sticks out.
Yeah. Nonetheless, the added fact that typically the contract gets interpreted against the draftsman. So if Allstate's drafting their own policies, it's just laughable. They're not even accurate with what they're claiming, even though they're the ones that wrote the policies.
Yeah. Well, and especially under Texas law when you're right, the policy or the contract gets construed against the drafting party with extra force, special force when it's a sophisticated party dealing with a less sophisticated party.
And regardless of any war stories you may have, Allstate is technically probably considered a sophisticated party.
Right.
Right.
Yeah.
So
sophistication's a relative term, but yeah. But under the law, you're right.
Right. So I want to provide some value for anybody watching this. So contractors, PAs, anything. What's a couple of good takeaways from this story that they can add to their arsenal, to their belt loop, to be more effective in the field from a legal perspective?
Right. Well, here's a trend that I'm really seeing a lot, and I've gotten great results for clients.
Okay.
And what I learned from that case is never underestimate the stupidity of an insurance company or their ability to read terms into their own policy that aren't there. Just because that adjuster says, oh, it's cosmetic damage, right? Don't just use the term cosmetic. Go back and look at that cosmetic exclusion. And especially when engineers start coming into the picture.
Okay.
These engineers, they're often using their own standard of what cosmetic damage is, right? So, for example, like in the Allstate case, their engineer was not allowed to testify. Their expert who said 1-inch hail.
Right.
He wasn't allowed to testify on the issue. The judge wouldn't let him because the standard he used of cosmetic damage was not the same one as the one in the policy.
Oh, I see.
Yeah, the policy says it has to only affect the appearance, and he was saying, no, it has to affect the water shedding ability and the service life of the roof.
Right.
Well, that's not in the policy.
Right.
And so Donen, Hague, the Hague Field guidelines, they have their own definition. Look at what that engineer is defining it as. And 9 times out of 10, you're going to find that engineer never looked at the policy, never thought to look at the policy, and the language he's using doesn't match what's in the policy.
Right.
Now, that's a problem for them because whose burden is it to prove that it's cosmetic damage? It's the insurance companies, right?
100%.
Yeah. And so if they're not even using the terms of the language, I think a contractor or public adjuster or homeowner can get some mileage out of that.
Right. And that's a quick little tip right there. Just definitionally, what is cosmetic damages?
Right. And the other thing I'd say is keep it in your head about whose burden this is.
Okay.
Remind them that your adjuster came out and he looked at the roof. How does he know that it only affected the appearance of the roof or that it hasn't affected the service life or the water shedding ability, whatever the standard in the policy is? Let me give you another funny story about that. I didn't get to handle this case, but Rick Daly did. And he deposed the insurance company's expert on this. It was a case out in New Mexico, metal roof, cosmetic exclusion. And so he's asking this expert, it's your burden and the insurance company's burden to prove this is only cosmetic. How do you know that? What test, what method did you use? How do you scientifically know? And he said, well, it's an old roofing trick. You lick your finger and you rub it in the dent, the scrape, or whatever. If you got rust on it, then it's functional, non-cosmetic damage. If you don't, then it's cosmetic. And so for the rest of the deposition, Rick just kept calling it the spit and wipe test.
Spit and wipe. That's a ridiculous.
The old tried and true, scientific spit and wipe. Which of course, the judge later, there was no way she was going to let Joe Blow, expert, testify about the spit and wipe test.
Well, one of those words you said, scientifically proven.
Mm-hmm.
A spit and wipe doesn't seem. There's nothing scientific about that.
No.
Right?
No. It's absurd. And their case started to fall apart. We got a really good settlement for it was a church, I believe, after that. You know, a lot of times it's just a visual observation that they're doing.
Right.
If you go, a lot of contractors and PAs watching this will understand what ASTM means. You know, these tests that have to be applied to the materials. It's not the insured's burden to make sure and apply these tests and everything. And look at the engineer. I mean, did he actually apply any of this stuff if it's relevant? I think by beating up the insurance company with their own words in the policy, you can get a lot of mileage against them. Right? At least I know in the courtroom I can.
For sure, because it's a small jump from them using the wrong definition in tandem with doing a spit and wipe test to you transition to them getting struck in court. Essentially, that's what we're working for towards, right?
Right.
And then the insurance company has no more experts to go on the stand and testify.
To meet their burden.
To meet their burden.
Right.
And without meeting your burden, who automatically wins?
Right.
We do.
Yeah, we do.
So
because there's no question that we've met our burden to show a hailstorm
right.
struck the roof.
Right. A quick takeaway. Burden initially to prove that there's a hailstorm, prove that there's hail. Burden shifts to the insurance company to prove what?
Well, to prove that it's merely cosmetic damage and therefore is not covered.
And then it goes back to the first party, the policyholder.
Yeah, well, and let's not get ahead of anybody watching. That's a good point, right? So study the cosmetic exclusion, because sometimes it's not merely an exclusion. There's also what's known as an exception within there. So the way it works is, right, you have general coverage. You have to prove a sudden accidental loss. And then you might have a cosmetic exclusion in there, or a foundation exclusion, whatever the exclusion is. And within that exclusion, there's sometimes an exception to the exclusion, right? So like in the Allstate case, there was an exception to the exclusion that said, you know, what's excluded are scrapes, dents, dings that only affect the appearance of the roof. However, if the roof is leaking in any way, it didn't say it had to have a hole in it, right? It could be the seams are bent.
Right.
If the roof is leaking in any way, that's an exception. And so the way the burdens work, we got the burden to prove there was a hailstorm. Then they have the burden to prove it was only cosmetic. And once they've met that burden, then it would shift back to us, right, on the exception.
To see if there's an exception to the exclusion.
Right.
Got it.
And hold that exclusion over them. Some of those cosmetic exclusions they have that exception. And the exception, by the way, is always going to be at the end of the exclusion. Right?
Okay.
I don't think I've ever seen one where it's up top or in the middle. Look at the end of it and ask yourself, is that an exception to this? And you can beat them over the head with it. Right, those ones that say if the roof is leaking in any way, you know. Right.
Nice.
Yeah.
Okay. Cool. Well, that's some pro tips right there. And then if you don't want to do it on your own, contact Daly Black. We'll help you out with that one.
Yeah, I think so. I encourage. I mean, anybody who just wants to talk about, nerd out. Clearly, I like nerding out.
I do too.
Give me a call.
Yeah.
Right. I'd be happy to talk to you about this stuff, or tell me what you're seeing out there in the field. I'd love to hear it.
Absolutely.
I love it when somebody brings a new policy to me that I haven't seen before. I'm really not fun to have a cocktail hour.
I'd invite you to my cocktail party. I enjoy it.
Oh, that sounds riveting.